Scott McNamara joining us on the phone right now, the Oneida County DA. Hey, Happy New Year, Scott. How are you?
Good. Happy New Year, Dave.
Happy New Year. And choking, one of the only things left out of the article this morning that we've been talking about as regards to the Word of Life Church.
Yeah, sex abuse, witchcraft, and voodoo. Wow, this is getting salacious, Scott.
Yeah, I can't really talk about that. Those are the allegations in the case, so I can't really talk too much about that.
Mm-hmm. But
it's a public document that the OD was able to get a hold of. So
I see. Okay.
And some of those allegations were brought up early on as we, learned about what happened and what transpired at the Word of Life Church. And I believe at one point on our show, some of the sexual abuse allegations that were being tossed around by the two young men there, I think you debunked them, if I'm correct.
Yeah, I really don't want to talk about that. I would urge the listeners and the public at large to wait until we can try this case, and then all of this information can come out in the way it should in a public trial, and then I think at that point it'll make a lot more sense, and everyone can then make a decision on what did and didn't happen. But obviously in this case, and in every case, the defense is entitled to what's called a bill of particulars. And in cases where they ask for it, we have to file it, and it expands upon what our allegations are. And I remind everybody too, because one of the things that I'm most concerned about is that the 8 individuals that are left at this point do receive a fair trial. And a lot of times what happens is when all these things come out, people start saying, "Oh, that must be true," or that, or this is true, or that happened, and at this point, all of the 8 people left at this point are all presumed innocent, and these are mere allegations that we are still required to prove beyond a reasonable doubt in a courtroom. And and I think that's probably going to happen. We'll probably have at least one trial. Well, we'll definitely have at least one trial, I would think, and I'm guessing at least 2 trials because some of these people can't be tried together for legal reasons. So then the public will be able to find out what took place and what the allegations were.
All right. And among the defendants, Scott, most have rejected plea offers so far, although one has accepted. Were you surprised by that ratio?
No, not at all. I mean, we're not really making offers that would entice somebody to plead guilty.
Right.
So no, I'm not surprised. And based upon just this case, it's a case that that typically when we see these type of cases, you kind of, as a prosecutor, especially someone that's done a long time, there's certain cases we kind of know are going to end up as a trial, and this is one of those cases. And so I'm not surprised by that. Like I said, we didn't make offers that would entice people to plead guilty. So
yeah, do you do that in other types of crimes?
What, make offers that don't entice?
That
people?
wouldn't.
Yeah.
That would be more attractive, perhaps.
It's each case depends on, and that's a great question, and that's something that I'd definitely be more than willing to come on at a different time and talk to you about.
Okay.
About plea bargaining, because there's a presumption of what we do and when we plea bargain.
Mm-hmm.
But typically what happens in a case is, in every case in county court, we're required to make an offer. And sometimes the offer, like, for example, in the Adam Thiel case, and he was the gentleman who, gentleman's probably the wrong word, the individual who killed his baby by placing him on the end of a shotgun and then shooting the baby. In that case, we came to court and said, Your Honor, we're asking the defendant plead guilty to the top county indictment, and we want you to give him the max. And that doesn't mean the court has to. The court has a range in which they can sentence somebody. So on a murder in the second-degree charge, the minimum sentence that a court can give if the person's convicted of it is 15 to life, and the maximum is 25 to life. So when we say plead to the top count, the sentence is totally up to the court. So what we typically do on those cases where we feel that there is no reason to plea bargain, or we just don't feel that the facts warrant any reduction, we'll say plead to the top count, and then really what we're doing is recommending a certain sentence. The court can do as the court sees fit. within the range that the law provides.
Talking with Oneida County DA Scott McNamara at 100.7 FM WUTQ.
And Scott, one of the questions that we got into yesterday in regards to plea deals or plea offers, is it the discrepancy of your office to give a time frame or a timeline in which a defendant may be able to accept the plea, or how long the plea is on the table for the defendant?
See, that's really not up to us. This is how it works. We come into court. We have to make an offer. So if the offer's plea to the indictment, that's there's not a lot there. In some cases, let's say for example, we have a case where either the facts, the evidence is weak, or we've got a witness that we're concerned about. Like when you're talking about sex crimes against children, we're wondering how much damage do we do by putting the child on the witness stand again. So those type of cases, we might say if you plead to a reduced charge, we'll recommend a certain sentence. But the time frame that's allowed for the defendant to make a decision is not set by the DA's office; it's set by the court. And so typically, what happens is the court will make us make an offer, and it's usually at the arraignment time when the defendant's first brought into court and arraigned. The judge will ask us to give an offer. Sometimes, as is in this case, the judge arraigned them and then set a date in the future where we made the offer, and then the defense had a period of time to contemplate it. But that time is set by the court. It's not by the DA's office. And and typically, if we make an offer, that's our position on what we want. What we think the appropriate sentence would be. And that's usually when we're plea bargaining, what we're negotiating for is what we feel is the appropriate sentence. You're usually talking, a plea bargain, let's say on a drug case. If you're talking about a B-level felony and you're taking a plea to a C-level felony or a D-level felony, you're still getting a felony conviction. And what we're really negotiating for is what we think the proper sentence would be. So the time period that the defendants have to contemplate it is not set by us, it's set by the court.
What about the time period for the trial itself? Do you have any sense of how long this would last?
I don't at this point. I can tell you what would happen next. After the motions are filed, which the court is giving the week of, it's like the 16th, 17th, 18th right now. It's that time period in February. The week after is the day we have to answer. And then based upon our answers, the court would then have to schedule hearings if the court deems hearings are necessary. I would anticipate there would be some hearings in this case just based upon some of the evidence that we have. So I would anticipate we would have some hearings. And then after the hearings are all concluded, then the court would set a trial date. So it's hard to guess, but at this point, I don't think that would be done much before. I don't think there would be a trial much before May at this point, but I could be wrong on that. It's a guess on my part.
Talking about the Word of Life Church case with the Oneida County DA Scott McNamara on the Talk of the Town.
And Scott, I know, I believe yesterday you made some mention of how this may play out with so many different individuals involved here, and how will that and what will that mean, I guess, for your office as you look at the cases individually? I think you were talking yesterday of the fact that one trial may coincide or butt up with another one. Is that how it would play out?
No, I didn't say that. I don't know who said that. I don't know at this point how that's going to take place. I mean, that's all stuff that we're going to have to talk to the court about and the defense attorneys about. When they would be tried, in what order. I mean, right now, the only thing I can say that I believe at this point is that we'll have to have at least 2 trials based on some legal reasons why certain defendants can't be tried with other defendants. That might turn into 3 or 4. I'm not sure. That's up to the court. That's not up to the DA's office. But it's too early to say how that would take place. I mean, obviously there's some issues. When you try one case, everything that's testified to is in the legal terms is called Rosario material, and we have to provide that anytime that one of our witnesses testifies in another proceeding. So I'm not quite sure we could try 2 cases butted up next to each other like that. I think legally there might be an issue with a Rosario, which is prior statements of a witness. issues that might ultimately, if you violate that, you could be required to retry the case, and that we really don't want to do that. So there's a lot of things that as we go forward, we're going to have to look into legally how we would do this. And obviously, if we're going to have to try the case at least 2 times, because of legal reasons, because of the amount of defendants we have, we sure don't want to be doing anything that's going to make us retry any of these cases. So.
And last time that we spoke with you, some things have transpired since in the Paul Bumble case. Can you give us a little update on that?
Sure. As the last time we talked, Mr. Bumble entered a plea of not responsible by reason of insanity. The court ordered, which is required by law, that an evaluation was done of him. That evaluation, the people that were supposed to do that had asked the court for an adjournment on it. So right now it was supposed to have been reported, I think it was a week ago now, and they asked for an adjournment. So it's adjourned for that report to come in. And the judge, I don't think, has set a date for that. I think he's going to wait for the report to come in and then contact the defense attorney and contact my office and set a date once he gets the report.